Assalamualaikum and have a nice day, sir. My name is Elza Binti Zainodin. My student ID 6221312427 and I'm from class BA58A. So today I would like to present this individual assignment about the impact of the law of tort on the accounting profession with the main topic negligence of tort. First and foremost, I will start with the introduction about the definition of tort and negligence. Tort law addresses wrongful acts arising from a duty of care owed to others and is primarily compensatory, awarding monetary judgment for losses or damages. Thus, it encompasses the three main types of claims, such as strict liability, fraud, and negligence. Negligence involves assessing whether a lack of reasonable care caused harm, considering factors like severity, foreseeability, and precautions. It also applies to professionals failing to exercise reasonable care in providing expertise to clients. Next, we go to the literature review about does an accountant firm owe a duty of care towards individual shareholders in their client company. Okay, this part basically tells us about accountant's responsibility, role of accounting firm, and the case reference. Okay, we go to the role of accounting firm. First thing first, accounting firm need to provide financial services to corporation and individual shareholders. To debate exists on whether accounting firm owe a duty of care to individual shareholder. Okay, the example of case reference is about Indi, Sina, and Enor, Vina, Taro, and Ors 2020. The court considered if accounting firm advising a company owe a duty of care to its individual shareholders. It also raised fiduciary duty questions concerning accountant's obligations toward shareholders. Okay, next we go to accountant's responsibility. Accountant must ensure that accuracy and compliance of financial services of their clients. They also debate whether this responsibility extends to individual shareholders. Okay, now I will explain a little bit about the key legal cases, key legal statutes, and key scholarly articles about the case I said just now. Okay, for the key legal cases, I will talk about the background of the cases, key finding of the court, and legal principle established. For the background, this case involved a family-owned business undergoing endemic damage. The claimants accused Bishop Fleming as the accountants. So for the key finding of the court, they find about accounting obligation, fiduciary duties, and duty of care. Last but not least, about key legal principle established about accountants' primary responsibilities and shareholders' responsibilities. Next, we go to key legal statutes. For the key legal statutes, we have Companies Act 2006 from UK, based on Section 12172, specifically states that a director's responsibility is to act in the company's best interest. And the second one is Section 393, requires financial reporting to be accurate, meaning that an accountant must create correct and compliant records for the business. One is about the auditing practices board EPB ethical standards. The example of this statement is Caparo v. Dickman, where proximity between parties they have foreseeability of harm, whether it's fair, just, and reasonable to impose a duty. The implication of the ruling is no duty of care owed to shareholders due to lack of proximity, and shareholders advised to seek independent advice. Last but not least for this part is key scholarly articles. So here I listed two articles which is accountant have no duty of care to a third-party investor. Is it true? Okay, let me explain. Accountants owe a duty of care to their client, typically the corporation, not shareholders or investor. Obligations are limited to the term of the engagement agreement. In Disina Vinataro 2020, court ruled accountants hired by a company have no duty to individual shareholders. Shareholders must not rely solely on accountants' work on business transactions. The second article is about professional negligence and fiduciary duties in accounting. This tells us about fiduciary duties and professional negligence arise only with a clear agreement and undertaking. In Disina Vinataro 2020, they tell us about no fiduciary duty or duty of care arise because accountants were hired by the company and shareholders were advised to seek independent advice. Last but not least, professionals are liable to third parties only with a direct relationship or express obligation. Okay, we go to the next point about legal framework. I will explain about principle of tort law, which has 2 points about duty of care and breach of duty. Okay, Firstly, the duty of care of tort law states that accountant must not cause harm to their clients or employers. Court limit this obligation to close relationship or proximity between the accountant and the party claiming harm. Extending liability to third parties can result in unpredictable claims. Thus, accountants' responsibilities are generally confined to their direct clients unless explicitly agreed to act for others, ensuring clarity in their obligations and maintaining professional accountability. Next, we go to the breach of duty. A breach of professional standards involves an accountant's failure to maintain adequate financial statements, follow regulations, or provide good advice. This can lead to financial loss or legal issues. Next, we go to obligation for accounting. I have 2 points, which is accuracy and compliance, and also confidentiality. We go to accuracy and compliance first. Accountants are responsible for accuracy and compliance as their work significantly impact clients' financial health and legal standing. Accuracy involves providing accurate financial information such as audits, tax return, and financial statements to avoid significant losses and damage to a company reputation. Compliance involves adhering to applicable laws, rules, and professional standards. This to ensure accurate tax filings and adhering to financial reporting guidelines such as international financial reporting standards. Next, we go to the confidentiality. Accountants pledge to safeguard confidential clients' information in business or financial transaction. Furthermore, poor advice from lack of diligence can also cause injury. By using safe storage procedures and sharing it legitimately for professional purposes like audits, this duty extends beyond client relationship, protecting clients' interests and maintaining sector integrity unless required by law. We continue to the case study about Hadley Brink and Co. Limited v. Heller and Partners Limited, 1964. This included about facts, legal issue, decision, and key principles. We go to the facts about this case, which Hadley considering to do business dealing with E&Co. Heller, who confirmed that E&Co was financially but without responsibility. For the legal issue, we find Hadley Brink claimed that the information from Heller was negligently and misleading. The decision for this case is the court assumed negligence but held that the disclaimer negated any duty of care by Heller and they were not liable for the loss. The last part is about key principle. If no disclaimer had been present, a duty of care might have arisen based on the circumstances. We go to the next case study, which about Kaparo Industry PLC v. Dickman, 1990. The facts tells about Kaparo Industry purchased shares in Fidelity based on financial statement audited by Dickman, showing a profit. Fidelity operating at a loss, causing Kaparo to suffer financial harm. The legal issue, we questions about Dickman as auditor or a duty of care to individual investor like Kaparo, and the decision made about the House of Lords rule, there was no duty of care towards the Kaparo, and auditors prepare reports for shareholders collectively, not for guiding individual investment decision. For the key principle, the court established threefold test, which is foreseeability of harm, fair, just, and reasonable, and relationship of proximity. We move to the next part about risk management strategies. In the context of tort law, risk management strategies are essential for professionals including accountants to mitigate the risk of liability and ensure compliance with legal and professional obligations. Furthermore, risk management is the process of recognizing and evaluating different risks that could impact your accounting company. From financial or legal uncertainty to security and data concerns, these risks can be found anywhere. And now I want to talk about the risk management strategies that accountants can implement to mitigate tort liability. The first point is providing clear and accurate advice to avoid miscommunication and have proactive communications. Since clients rely on an accountant's professional judgment when making important financial decisions, providing clear and suitable advice will be crucial to avoiding tort liability. Then, the next point is engaging in regular training to stay current, enhance professionalism, and boost client confidence. Being current creates confidence in the relationship with the client, since the clients are assured that their accountant is knowledgeable about the current issues. In the end, taking part in ongoing education improves the general caliber of professional services performed while also reducing liability concerns. And the last one is about best practices for compliance with tort law. Before providing any risk-free and successful advice, the accountant should have an in-depth knowledge of the client's unique needs, goals, and circumstances. Basically, while understanding the needs of clients, the vital part of accountants involve gathering comprehensive data about their financial situations, goals, and regulatory requirements. Moreover, accountants also have to understand the regulatory requirements. To this is in view of compliance, having in mind the specific laws and regulations to which the industry, jurisdiction, or financial situation of the client may be subjected. Last but not least, we go to the conclusion part. Tort law principles such as duty of care, breach of duty, and proximity define professional accountability, particularly for accountants, as demonstrated in cases like Caparo v. Main and Hadley Brain v. Heller. Generally, accountants owe a duty of care to direct clients with limited liability to third parties unless explicitly extended. As clarified in Gisina v. Nataro, the responsibilities include ensuring accuracy, confidentiality, and diligence to prevent financial losses. To minimize liability, risk management strategies such as effective communications, continuous professional training, and client focuses practice are essential. Thank you.